Welcome everybody to Dorsey's Bank Counsel Roundtable on FinCEN's new beneficial owner rules and an update on Russian sanctions. I'd like to introduce to you Nick Vleetstra, a partner in Dorsey's Finance and Structuring Group. Nick?
Thanks, Matt. Good afternoon, everyone. I'm Nick Vleetstra. Welcome to this month's session of Dorsey and Whitney's Bank Counsel Roundtable, and thank you for joining us. We've prepared a presentation today on FinCEN's final beneficial ownership regulations, as well as an update on Russia sanctions. Our speakers today are Dorsey partners Erin, Bryan, Joe Lynyak, and Larry Ward, whom I'll introduce shortly. First, I want to take care of a couple of housekeeping details. Today's program is scheduled for 60 minutes. The materials for the presentation, as well as the attendance form, are available for download through the reminder email that went out to registrants on Friday from events@dorsey.com. During the presentation today, there will also be links sent to you via the chat function for the attendance form and the materials. The CLE code that will also be noted in the chat room will be noted in the chat room when it's announced by our presenters. Just a reminder, you should send your completed attendance form to attendance@dorsey.com, and then certificates of attendance will be sent to those who return the completed form. Today's PowerPoint deck will also be accessible via a link that will be included in the survey email that will be sent out to you tomorrow. Also, please note that we will not have Q&A during or after this presentation, but if you do have a question for our speakers, you are welcome to contact them directly or through your usual Dorsey contact. The speaker's contact information can be found in the presentation materials with their bios. Okay, with that out of the way, let me introduce today's speakers. Erin Bryan is a partner in the Finance and Restructuring Group at Dorsey and is co-chair of our Consumer Financial Services Group. Erin is a member of the American Bar Association Banking Law Committee and is vice chair of its subcommittee for bankruptcy and workouts. She is also on the board of the Turnaround Management Association's Minnesota chapter, and Erin works out of Dorsey's Minneapolis office. Joe Lynyak is also a partner in the firm's Finance and Restructuring Group. He's a nationally known bank regulatory lawyer practicing out of the firm's DC and Southern California offices. And Larry Ward is head of the firm's Seattle office and is co-chair of our National Security Law Group. Additional biographical information on all three of our presenters is included at the end of your materials, as is their contact information. And with that, I hand you over to Erin Bryan. Take it away, Erin.
Great, thanks so much, Nick. In today's roundtable, Joe Lynyak and I will analyze the final beneficial ownership information, or BOI regulations, that were issued by FinCEN on September 30th, 2022. In particular, we will identify and discuss important changes between the proposed regulations and the final version. And we will explain the challenges that these regulations present to lenders, borrowers, and lawyers, including the potential tsunami of filings that could occur in the next 2 years. Finally, Larry Ward will provide an update on the status of the federal government's Russian sanctions, including a discussion of important differences between the emphasis being placed on Russian sanctions and other U.S. sanctions regimes. In January of 2021, Congress adopted the Anti-Money Laundering Act of 2020, or AML Act, which included long-sought reforms of a number of federal anti-money laundering laws. The AML Act was based upon a clearinghouse review of U.S. AML laws coordinated in 2016 and 2017. The review included stakeholders from the financial services industry, as well as current and former representatives of government law enforcement agencies, including FinCEN. In February of 2017, they issued a comprehensive report titled A New Paradigm, Redesigning the U.S. AML CFT Framework to Protect National Security and Aid Law Enforcement. 2020's AML Act represents a delicate balance between mandating general reform of the U.S. AML enforcement structure while stopping short of mandating specific reforms. To inform implementation tasks by FinCEN and Treasury, the AML Act amended the AML policy goals. First, with respect to data sharing to improve coordination and information sharing among state and federal agencies tasked with administering AML requirements. Second, with respect to new issues like cryptocurrency, to modernize AML laws and other anti-terrorism laws, to adapt the government and private sector response to new and emerging threats. Third, to encourage technological innovation and the adoption of new technology by financial institutions. Fourth, to adopt a risk-based system of policies and procedures for financial institutions. And finally, and this will be the focus of today's presentation, to establish a new non-public beneficial ownership database to be used by FinCEN, financial institutions, and others. This last development is going to be crucial for attorneys at financial institutions to understand, which is why we're focusing on it at today's roundtable. As I stated previously, the AML Act included a general directive to issue comprehensive regulatory AML reforms. It also strengthened FinCEN and directed Treasury to cooperate with international and domestic law enforcement organizations, to regularly solicit feedback from financial institutions, prepare numerous reports on various AML issues, and issue interpretations in order to assist financial institutions and others with compliance. All right, turning now to beneficial ownership information. So going back to the Corporate Transparency Act, or CTA, this was a critically important component of the legislation. The CTA requires FinCEN to establish a database for the registration of legal entities called the BOSS, a term which sounds surprisingly suggestive of organized crime, considering that this is part of an effort to prevent illicit activities. But it's estimated that 2 to 5 million of the new legal entities created each year will be required to file reports. The CTA does focus, however, on smaller corporations, LLCs, and similar legal entities. It requires covered entities to register upon formation or registration and to amend reports upon changes in ownership or management. For existing legal entities, it requires that an initial report be filed within 2 years of the effective date of the required regulations to be issued by FinCEN. Importantly, the CTA is a major departure from the current scheme of FinCEN's CDD regulations regarding the identification of the beneficial ownership of legal entities. We note this because the current CDD regulations merely require banks, other lenders, and certain other financial intermediaries to obtain limited BOI prior to engaging in a covered transaction or an account relationship with a legal entity. The current CDD regulations only require BOI for an individual owning 25% or more of a covered legal entity, and at least one management official authorized to direct the operations of the legal entity. The final rule, however, is, as I said, a dramatic departure. It requires specified reporting companies, including domestic and foreign corporations, to submit to FinCEN BOI identifying their beneficial owners, meaning all natural persons who own and control them, as well as information about the persons, which are termed company applicants, who form or register reporting companies. Joe will be talking more about the ramifications of this in his portion of the presentation. It also requires them to submit updated BOI reports whenever a covered reporting company learns that the BOI report previously filed is no longer accurate. So next we'll go over the specifics of the final rule, including the meaning of the term reporting company, excluded entities, required information, required reports, required amendments, and beneficial owner information and company applicant information. The final rule establishes 2 categories of reporting companies that must file reports with FinCEN, termed domestic reporting companies and foreign reporting companies. A domestic reporting company means any entity that is created under state or federal law by the filing of a document with the Secretary of State, a tribal jurisdiction, or a similar office of jurisdiction within the United States. A foreign reporting company, on the other hand, means any entity formed under the law of a foreign, i.e. non-United States jurisdiction, that is required to be registered to do business within the United States. The categories of entities that would constitute a domestic reporting company are therefore extremely broad and include any corporate form of any entity created by the filing of a document with the Secretary of State's office or comparable office operated by an Indian tribe. This includes corporations, limited liability companies, and statutory trusts. Depending on a state's corporate formation requirements, however, this might not include sole proprietorships, partnerships, and many trusts. Notably, a filing with a Secretary of State's office to obtain a license or permit does not subject a legal entity to coverage under the final rule, because those are not considered chartering or creation filings. Now, there are many exemptions, 23 in all, and I will just highlight a few here. Banks, credit unions, depository institution holding companies, money services businesses, and large operating companies. The full list is available in the slides. Notably, a large operating company means any entity that employs more than 20 full-time employees in the United States and has an operating presence at a physical office within the United States and has more than $5 million in sales or operating revenue. A noteworthy omission from this list of exempted entities are law firms whose members and employees will frequently constitute company applicants. And with that, I will hand it over to my colleague, Joe Lynyak.
Oh, thank you, Erin. An early happy holidays to everyone who's on the Zoom call today. And we're going to be going through, as she mentioned, several different components of the rule. And the biggest difference is that it's not a matter of the financial institution begging a borrower to give them information. It's something which they're going to have to give now and give them directly to the federal government, which potentially increases to a significant degree their liability. Well, let's say you've identified a reporting company, whether it's foreign or domestic, and you've decided you have to make an initial filing. What do you need to give them regarding the company itself? Well, the first is the full legal name of the company, the trade name or DBA, which may involve filing in another, in the jurisdiction, because sometimes DBAs require that. A complete current address of the reporting company, the state, tribal, or foreign jurisdiction of formation of the reporting company, or in the case of a foreign reporting company, the state in which the state or tribal jurisdiction where the company first registers to do business in the United States. And then you've got to give them the tax identification number, which the federal government always wants everyone to have, including the employer identification number. And in the case in which a newly formed foreign company does not have a TIN number yet, a tax identification number issued by a foreign jurisdiction. Next slide, please. Timing requirements. This is important, and you will begin to see why this is going to create some issues possibly down the road. Under the final rule, the time at which a required report, including an initial report, is due is based upon the date the reporting company was created or registered, and whether the report is an initial report, an updated report providing new information, or report correcting erroneous information in a previous report. For domestic reporting companies and foreign reporting companies created or registered prior to January 1st, 2024, that's the effective date of the regulation. So about a year from now, anything created prior to that date, those entities would have until an additional year, January 1st, 2025, to file their initial reports with FinCEN. However, if you are formed on or after January 1st, 2024, those entities would be required to file their initial report with FinCEN within 30 calendar days on the date in which they are created or registered. Now, let's just take a step back here and next slide and give you an idea of volume here. What are we talking about in terms of volume? Well, according to FinCEN, the number that they estimate of current reporting companies that are not exempted, so ones that have to file initial reports that were created or registered prior to January 2024, is only 32 million companies and reporting companies. And again, we're using reporting companies to be as used in the regulation. So anything which requires a filing with the Secretary of State's office. And FinCEN also estimates that the cost of doing that to those companies, again, without incurring legal fees, close to my heart and everyone who's probably listening here, is going to be $21 billion. For newly formed companies on or after the effective date, they estimate that about 5 million reporting companies will be created every year that will be required to file initial reports. We believe that these estimated costs, and by the way, that cost will go down to about 3.3 billion. We think this number is actually wildly lower than what the actual fact will be, certainly in terms of the initial filing required for companies formed prior to January 1st, 2024. Subsequent filing requirements. Next slide, please. What FinCEN did, and I think this is a good idea, is they had a number of timing requirements, and they said, you know, this is just too complicated. Let's just come up with a consistent 30-day filing requirement for subsequent filings. When an updated report is necessary, and we'll talk a little bit about what that means. You're going to have 30 days, and if you find out that the information that you previously filed was not correct, you've got 30 days after the date you know or should have known that the information wasn't accurate. Next slide. Let's talk now about BOI, beneficial ownership information, which is in addition to the individual company information we just talked about. There's two categories of information in regard that have to be filed in addition to company information. One is specific BOI information of individuals owning and controlling the reporting company, and information regarding company applicants, which is driving corporate lawyers, making them at least a little bit upset. Let's go on to the next slide. BOI information to be provided. The rule radically modifies what constitutes a beneficial owner, and it means anyone who owns or controls 25% or more of the ownership interests in a reporting company, and all individuals who exercise substantial control over the company, meaning not necessarily ownership, but control over the company. If the individual serves as a senior officer of the reporting company, has authority over the appointment or removal of any senior officer, or directs, determines, or has substantial influence over, quote unquote, important decisions, a very well understood legal term made by the reporting company. So you can end up with a lot of folks who are going to be exercising control over a company, over a reporting company. Next slide. A senior officer is defined as several different things, and you can see here which they are: President, Chief Financial Officer, General Counsel, Chief Executive Officer, Chief Operating Officer, and then a very, very useful catch-all: any other person, regardless of what that person's official title is, who performs a similar function. So you could have 5, 6, 7, or 8 or more individuals who have got to be identified because they have got exercising authority over the company. And let's go on to the next slide. And this is kind of just a general warning we decided to throw in here to make sure everyone understands this. Under the old CDD rules, all you needed to do was to identify one person, whether it's a managing director or the chairman of the board, who exercises control over the company. Now it's anyone who is in a senior officer or who exercises substantial control over the company. So that means that you can have many individuals where you're going to have to identify and constantly file with FinCEN, depending upon how their situation changes. And I mentioned, we talked about important decision-making authority. Let's go to the next slide. They really try to tie this down into a nice bow and throw everything against the kitchen sink as to what constitutes having the ability to influence important decisions. The nature and you can influence the nature, scope, and attributes of the business, the reorganization of or merger of the corporation, and those types of transactions. Major expenditures or investments you can control or influence. Compensation schemes for senior officers, being able to influence significant contracts of the company, amendments to government documents, and then another really nice little throw in, any other form of substantial control over the reporting company. Again, very well understood legal concepts. Next slide. What's important again is to understand that in terms of control can be direct or indirect. It can include board representation, ownership or control of the majority of the voting power of the reporting company, rights associated with any financing arrangement or interest in the company. And we need to stop here. There is an exemption for creditors who have got protections in their loan documents dealing with indebtedness. And so it appears that creditors, the normal typical creditor who's got covenants limiting the operations of a company. They are not going to be considered to be controlling the company simply by nature of the indebtedness. Controlling intermediary organizations, arrangements or financial business relationships with other individuals, including individuals used as nominees, and again, any other contract arrangement or otherwise. Intermediate entities count. There's a limited exemption for a reporting company that's created by a exempted entity, and that has to be looked at very carefully. Next slide. Now, ownership interests themselves are very broadly defined. And you can see that FinCEN is saying, we want the name of everybody that either exercises control or owns a piece of this company where it goes over 25%. And that starts out with an equity stock. Ownership interest means an equity stock or similar instrument without regard to whether the instrument is transferable, is classified as stock, or confers voting power or voting rights, any capital or profit interest in an entity, regardless of whether or not it is characterized as equity or debt, any type of convertible instrument, many future instruments, except when you're dealing with inheritance issues, and any put call straddle, or, and again, as a catch-all, any other instrument, contract arrangement, or mechanism used to establish ownership. Again, very easy for the average person to be able to figure out. I'm sure everyone's going to be able to answer these things very clearly. Next slide, please. The final rule also states an individual may directly or indirectly own or control through contract arrangements, joint ownerships, through the use of a nominee, an intermediary, custodian, or through a trust. Now, employees and nominees are not going to be control people. And typically a trust, if it's not going to be a statutory trust, is not going to be a reporting company, but the trust itself, or the trustee, beneficiary, and the grantor or settlor may be having control over the company, and therefore those individuals may have to be identified by FinCEN, even though the trust itself may not be a reporting company. We don't have enough time in this presentation to talk about the types of calculations that have got to be made, but as some of you who are familiar with the formation and also with the structuring of companies, including, for example, fintech companies, know this can become very, very complicated, and telling people that it's necessary for them to be able to go and figure these things out and get information is probably going to take a great deal of time and effort to be able to figure this out properly. Information to be provided. And once we figure out, next slide, please. Once we figure out who's got to be identified, we've got to identify the beneficial owners and the company applicants. And we'll get the company applicants in a moment. But in terms of beneficial owners, which again can be ownership interests or control people, you've got to identify the full legal name of the person, the date of birth, the complete address, a unique identifier of the beneficial owner, such as a passport, which typically is going to be a U.S. passport, but it can be a foreign passport, a government ID, a driver's license, including the mugshot of the individual, and in some cases, a copy of the of the document itself, such as the facing page of a passport, may have to be used. In the case in which a beneficial owner owns a reporting company through an exempted entity, you can identify the exempted entity rather than the beneficial owner. That's a gimme that they put in there. Why? It's because public companies and large companies, the information is generally going to be available, and the intention here is to avoid companies where it's difficult for the government to identify who is owning what and how these things are being operated. Next slide, please. And now the fun part, company applicants. The final rule requires that individuals who organize or register a reporting company must be identified. For a reporting company, a company applicant is the individual who directly files the document that creates the domestic reporting company. So, you go down to the state Secretary of State's office and you file it. For a reporting company, a foreign reporting company, a company applicant is the individual who directly files the document that first registers the foreign reporting company in the United States. That's pretty straightforward. However, for a domestic or foreign reporting company, the individual who is primarily responsible for directing or controlling the filing has got to be identified as well if more than one individual is involved in the filing of the document. So that means there can be several people who are going to be company applicants that have to be identified. Next slide. It includes an individual who's primarily responsible for directing and controlling the filing if more than one individual is involved in the filing of the document. Now, what does that mean? Well, if a reporting company is formed or registered by a law firm, which happens very, very frequently, there will be two company applicants. The senior lawyer directing the creation or registration of the reporting company, and, for example, a paralegal, a junior associate, or a similar employee that actually does it and gets the thing filed. And during the comment period to the proposed rule, corporate lawyers really indicated their concerns about this obligation, and because they thought they might be inundated by people demanding information, and whether or not that was fair, whether or not they had that information, whether or not people were still involved, they may have retired, they may have left, and so forth. And the final rule then exempts companies who were created or registered before January 1st, 2024 from identifying company applicants. So the 32 million people we're talking about, 32 million reporting companies we're talking about a moment ago, they're not going to have to identify the company applicants. For those formed on and after January 1st, 2024, the reporting company will be required to provide information on a company applicant. Next slide, please. Let's just, while we keep coming up with scenarios which are going to cause problems, let's just talk about a problem which we believe is clearly going to occur. And we've asked FinCEN about this, and they have not really responded to us about it. As we spoke before, a reporting company must file an amended report within 30 days of learning of the necessity of making that filing if the BOI changes or it's determined to be inaccurate. Newly formed companies, particularly companies that are engaged in transactions, whether it's lending transactions, construction transactions, or whatever, may be required to make several successive filings based upon the manner that the newly formed reporting company oftentimes finds itself in when they create their operating and capital structures. So, for example, a reporting company is organized and must file an initial report within 30 days. Okay, we know we have to do that. But if its operating structure is established outside the 30-day limit, following the adoption of the corporate structure, an amended report must be filed. And then again, borrowing from the experience of, say, fintech companies, where there are several different rounds of fundraising, after each capital raise, there may be a change made over who is a controlling party holding a beneficial ownership interest in that entity, and therefore another report has got to be filed. And this is something which is not on the company applicant. This is on the reporting company itself. And so therefore you can see the complexity and also the need for a higher degree of sophistication on the part of companies that are being created to make these filings, because there's something which we're going to hear about in a moment. Next slide, please. The CTA makes it a crime and imposes civil money penalties as well for making false reports regarding a reporting company. It's a crime. It's also a civil money penalty. And what people are now beginning to realize is, all right, who's obligated? Well, the language itself is somewhat imprecise in that the reporting company is obligated to make the report, but a person who is involved in making the filing theoretically has got an obligation. So there's a question as to what is the degree of due diligence that is necessary in order to be able to make the filings, who is obligated, and anyone that is involved in it filing the report has got to certify the report is, quote unquote, true, correct, and complete. I don't want to file those things. I don't want to sign those things. And again, you can just see how dealing with third parties helping you out, there's probably going to be a rearrangement of what the obligations are of third parties, as well as the obligations are of reporting companies when they're formed, and all of these filing requirements become important because you are no longer dealing with a bank, you're dealing directly with the federal government, and there is heightened liability. Next slide, please. As we mentioned a moment ago from Erin, this final rule is just a start. It addresses the legal entities that must file with FinCEN, when filings must occur, and the information that must be provided. But FinCEN, over the next 18 months or so, is going to issue 2 additional regulations dealing with the protocols for accessing the BOI database by permitted users, and that's going to be law enforcement officials and as well as financial institutions under the CDD rules, and maybe others. And revisions to the actual CDD regulation itself, we all hope that means there's going to be less compliance requirements and not more. But we're going to have to wait and see what FinCEN decides in that regards. So it's a complex new regulation. It's going to be, the complexity is going to be enhanced probably by the lack of sophistication on the part of a lot of people who decide to form new reporting companies. And the 32 million existing reporting companies, it's going to be a mad dash for filing as the filing date approaches over the next approximately 2 years. So we'll have to see what happens. And FinCEN has also already indicated the fact that they will be issuing interpretations to help us all through this morass as questions become to be answered, because again, the regulation itself is not that long, but the ambiguity created in terms of what constitutes the proper analysis may be a daunting challenge. So that's an overview. And now we are going to move on to Russian sanctions, and our colleague Larry Ward, who's going to give you an update as to where we stand on that. Larry?
Thank you, Joe. So as Joe mentioned, I'm here today to provide an update on Russian sanctions that the United States government has imposed. The Russian sanctions program, before I get started, is quite possibly the most complex web of sanctions that the US government currently has. The sanctions program itself has evolved rapidly over the course of this year, starting just after Russia's invasion of Ukraine. And since that time, various US government departments have been imposing sanctions on various entities within the Russian government, on various individuals and companies that are owned by Russian oligarchs. And so it has really, from a compliance perspective, been very difficult to track all of this. It has truly required real-time tracking. Oftentimes, sanctions programs are very slow to evolve. Oftentimes, it's a bit of a political battle back and forth between two countries before sanctions will be imposed. But here, this program is very different. The United States government has responded swiftly and rapidly, although there has been coordinated effort with our most allied nations and regions of the world, so that we're not overstepping a particular sanction that another country or region's imposing. There's been a delicate dance between what the United States can impose versus what the EU can impose. But at the end of the day, it has meant it's a compliance headache for those of us that are left to deal with this on a day-to-day basis. So on the next slide, I highlight several executive orders that laid the groundwork for the current Russian sanctions program. In 2021, there were two executive orders that President Biden issued. The first was directed at Russia's involvement in the 2020 election, related to malicious cyber activities or other harmful activities that are aimed at disrupting fair and free democratic elections and institutions. Although this executive order was very clearly aimed at Russia's efforts in the 2020 election, the executive order's wording was broad enough to allow sanctions if Russia is involved with efforts in other democratic areas of the world and trying to harm those elections. So this is a pretty broad-based executive order that does allow sanctions at those times. The next action by the Biden administration in the summer of 2021 was targeted essentially at the oil export pipelines that Russia was building to Germany to supply oil throughout the EU. There was a real worry and concern, obviously, on the part of the EU that depending on whether the US government were to impose sanctions on this pipeline, what it might mean to the EU as they would head into the winter months. And so this really involved a delicate dance between the State Department and the EU to determine exactly what efforts the United States government would take. In August and September 2021, the US State Department essentially began outreaching to various foreign companies, non-US companies, that were involved in these oil or energy export pipelines, and essentially started to tell those entities that if they continued to do business with the pipelines, the United States government would target them for sanctions. And so as a result, there were some companies that did pull out. This was an example of an instance where the US government used the executive order to serve as a basis of outreach to companies to voluntarily comply before they would become sanctioned. That obviously was just the start of what was to become a very rapidly evolving year of sanctions. In February, March, and April, the Biden administration issued 4 additional executive orders that allowed for various sanctions. The first executive order that was issued was aimed at 2 regions of Ukraine that Russia had invaded and was illegally occupying. And so as a result, the US government decided to impose a total embargo on those 2 regions of Ukraine. They essentially became treated just as Iran or Cuba or any of the other areas where we do have comprehensive embargo programs. And they joined the Crimean region of Ukraine, which has been targeted with an embargo for nearly a decade at this point. Then in March and April, the US took additional actions related to investments in the energy sector. And importantly for this audience, in March, there was an executive order that was aimed at a prohibition of the supply of US banknotes from the United States or by US persons to Russia. And in that same executive order, the US government barred US persons from exporting, re-exporting, or selling certain luxury goods to anyone in Russia. And finally, the last executive order in this slide was aimed at investments in Russia and essentially barred US persons from making new investments in Russia. On the next slide, I outlined the different OFAC programs that we now have that have essentially implemented the executive orders that I just discussed, as well as a host of executive orders that had been put in place during the Obama administration. So when you're talking about most countries with sanctions, there's typically only one set of regulations that you have to worry about, one set of regulations that essentially defines the world of prohibitions with respect to a particular country or region. But when it comes to Russia, because we've not wanted to impose a total embargo on Russia to this point, the US government has essentially taken a surgical approach, and they've sanctioned Russian individuals and entities under different sanctions programs, using those executive orders and 2 longstanding acts as the basis behind these different regulations. The set of regulations that came into fruition this year were the Russian harmful activities sanctions regulations listed in that first bullet point. These are the newest regulations with respect to Russia. The second bullet point with the Ukraine and Russia related sanctions, those sanctions have been in existence since 2014 when they were originally imposed by the Obama administration. That set of regulations, though, for a period of about 8 years, really was just a restatement of the executive orders that the Obama administration had implemented. And this year, because of how these sanctions have evolved, OFAC actually reissued this set of regulations in full, determined to add in certain general licenses, define certain terms that had not been defined within the regulations previously. And so it serves as sort of a companion set to the regulations that were imposed this year. Again, the US government can sanction an individual or entity under either of these sets of regulations. They essentially have been, the two sets of sanctions have been imposed for slightly different reasons, but essentially they work hand in hand to target various industry sectors of the Russian Federation. I also note on this slide the Belarusian or the Belarus sanctions regulations. Because of the way that Belarus has aided Russia in the invasion of Ukraine, the United States government imposed sanctions on Belarus as well. And so many of the sanctions that have come out of Belarus this year have been as a result of their direct ties and connections to Russia's invasion of Ukraine. I've also listed the sets of a bit more obscure regulations that also can be used to target individuals or entities from Russia for sanctions. Again, each of these is quite nuanced in terms of what it allows and who it allows the US government to sanction, but the US government essentially has been using all of these tools to set its sanctions programs with respect to Russian individuals. The Treasury and State Departments are the two US government departments that are really tasked with imposing sanctions. The State Department is the one that essentially sets the targets for sanctions, sets the foreign policy, and then the Treasury Department does the implementation of the sanctions through the various regulations that I've listed above and other regulations against other countries. But both the Treasury and the State Department very clearly aligned themselves with the goals of AML, CFT, and with the New York Department of Financial Services. So essentially, what we've heard from Joe and Erin in terms of concerns with respect to AML, those are top of mind to Treasury and State. And although the sanctions programs aren't aimed specifically at those particular activities, they certainly are mindful of those as they are setting their sanctions programs. And then the final thing that I list out on this bullet, one of the most interesting aspects of these Russian sanctions has been that in large part, US businesses that were entrenched in Russia really were not impacted by the Russian sanctions directly. And what I mean by that is that whatever activities they were engaging in did not run afoul of the prohibitions of the Russian sanctions. Because as I had noted, there's no total embargo on goods and services to Russia. And so there's still a lot of things that can be done in Russia, and you can still be in full compliance with the Russian sanctions regulations. However, many companies decided that because of the atrocities imposed by the Russian Federation's invasion of Ukraine, that they were simply going to pull their business out of Russia. They did not want to be involved in supporting the Russian economy. They did not want to be seen as perhaps propping up the Russian government. And so when I note reputational sanctions, I essentially just mean that many companies decided to take a voluntary approach and essentially impose a total embargo with respect to Russia and pulled out of Russia entirely. On the next slide, I get a little more granular with respect to the different actions that OFAC took throughout February and March of this year. Again, for this audience, the most important bullet on this slide really is the first one. So beginning in late February, OFAC named as SDNs 83 Russian financial institutions, including 4 of Russia's largest, most critical banks and many of their subsidiaries. And so that really, for the US financial sector, really meant that beginning in February, Many of the financial transactions that had previously been allowed with respect to Russia were no longer allowed because they were involving these Russian financial institutions. On the next slide, just after those initial actions by OFAC, OFAC then issued Executive Order 14024, Directive 2, which essentially barred U.S. financial institutions from opening or maintaining correspondent account or payable through accounts for or on behalf of foreign financial institutions designated under this directive. OFAC then implemented a new sanctions list called the CAPTA list, which is just an acronym for the correspondent account or payable through account. And essentially, from a compliance perspective, it meant yet again that there was another list to be checked, another list to ensure that you're complying with the sanctions on those individuals and entities that are included on the list. Importantly, Cyberbank and 25 of its affiliates were added to the CAPTA list at that time. On the next slide, the executive order, Directive 4 under the executive order also prohibited any U.S. person from transferring assets or engaging in foreign exchange transactions for or on behalf of the Russian Central Bank or National Wealth Fund. And so essentially, this is the beginnings of the U.S. government shutting off the Russian financial system almost totally. This was an unprecedented action. And it was done in coordination, close coordination with several leading central banks of our key allied countries or regions. And obviously the rationale was to directly aim and target the Central Bank of Russia. On the next slide, since imposing those various sanctions, the Treasury Department has issued various determinations under the different executive orders that the Biden administration has imposed. And essentially what these determinations do is they essentially target a particular industry sector of the Russian economy and delineate various activities that can be the trigger of sanctions that the US government imposes. And so if a company or an individual is seen to be operating in these sectors in certain ways, the US government can then go ahead and target that individual or entity for sanctions. Importantly, the US government took the step to indicate that certainly they can also impose secondary sanctions. So in other words, they can impose sanctions on foreign companies for participating in various activities in these sectors. So from a financial institution perspective, it's important to consider these different activities. Consider closely if you're looking to fund a particular transaction. As an example, it's really important to figure out, does that transaction fall within one of these industry sectors where an individual or entity could be targeted for sanctions? The final bullet just lists out two other determinations with respect to gold imports and also with respect to transport of crude oil, which are a little less important for this audience. But again, it just shows that the US government has taken a very intentional approach in terms of who and how it's implementing these different sanctions. On the next slide, it's important to remember that OFAC not only has direct prohibitions under its various sanctions programs, but it also allows for those sanctions to be felt through other prohibitions or sanctions. So facilitation is a concept under the sanctions regulations that essentially says if a US person can't engage in a particular transaction, they can't facilitate a foreign person from engaging in that transaction. So that expands the coverage of the sanctions. Causation violations are very similar. OFAC essentially treats causation to be facilitation, meaning if you're a foreign person and you engage in an activity that would violate the US sanctions, you can be targeted for penalties under the sanctions regulations. And then, as I noted, with respect to secondary sanctions, those are targeted directly at foreign entities and individuals for violating particular provisions of these prohibitions. And on the next slide, as I had noted, the US government really has ensured that they've taken coordinated actions with our closest allied countries. And it's been particularly difficult for financial institutions because they've had to not only comply with US sanctions, but have had to comply with sanctions by other nations and regions. And it's important to note that, you know, obviously the EU, Canada, our sort of chief allies are included on this list, but it's also important to note that places like Singapore and Switzerland are also now on this list of having imposed sanctions with respect to Russia. So it just intensifies the web that financial institutions must navigate in order to figure out the sanctions. On the US side, the guidance is typically clear. OFAC has issued hundreds of FAQs with respect to these Russian sanctions. There still are some gray areas, and there certainly will continue to be gray areas. With respect to the sanctions programs in many of these other nations, though, they don't have very clear guidance with respect to what the sanctions mean. And so it becomes very difficult to sort of navigate what you can and can't do. And then on the last slide, in terms of risk assessment, this is something that obviously financial institutions have to do on a very regular basis, identify the high risk areas. When it comes to Russia in particular, we've seen a lot of so-called shell games. So a targeted individual or entity transfers ownership of a particular entity to a family member or tries to take their name off of that particular entity's ownership list. But in reality, at the end of the day, it's still that same oligarch that is in charge of the entity. And so from a compliance perspective, it's really difficult to try to figure that out, conduct the proper red flag due diligence. And then certainly many of these oligarchs are flight risks as well. And so that also makes compliance challenging. And as I noted, complying with the different sanctions programs from around the world has just been extraordinarily difficult, not just for financial institutions, but for all international companies that operate across these jurisdictions. And with that, I will turn it back over to my colleagues.
Well, thank you, Larry, for that presentation, and thank you, Erin and Joe, and thanks also to our audience for your attendance and attention. Do remember to sign the attendance sheet and return it to attendance@dorsey.com. Don't forget that if you have any questions for our speakers, you'll find their contact information in the presentation materials, or you may reach out to your usual Dorsey contact to get a hold of the speakers as well. Planning for our next meeting of the Bank Counsel Roundtable is underway, so look out for your invitation to the next Bank Counsel Roundtable, and we look forward to seeing you again soon. Thank you very much.
Happy holidays.